Hello, everyone. Welcome to another live edition of Employment Law Q&A. My name is Alex Lucifero. I am an employment lawyer and disability insurance lawyer with Samfiru Tumarkin LLP. I also manage the firm's Ottawa office, coming to you live from Ottawa, Ontario, Canada today. You can see the fall colors in the background of my screen. Beautiful fall day today, but I'm not here to talk about the weather. I am here to talk about our favorite subject, and that is employment law, as well as disability insurance law. So if you are tuning in right now, or you're just catching us by chance on the live stream, this live stream is about your workplace. It's about your workplace rights. I'm an employment lawyer, and we are here to talk about any and all issues that come up in the context of an employment relationship, whether that's at the start of the relationship and we're dealing with employment contracts or offer letters or recruitment to employment, or any issues that arise during the employment relationship. If you are dealing with a difficult employer, maybe you're dealing with a disgruntled manager who's treating you poorly and maybe doesn't like you and is harassing you or bullying you in the workplace. If you're dealing with changes to the terms of your employment, if your employer is trying to change your hours of work or change your position or change your pay, of course, we deal with that. And we also deal with, of course, ending the employment relationship. And so if you've been let go from your job, or if you've reached a point where you feel as if you're being so mistreated that you have no choice but to resign your employment, it's important to remember throughout the employment relationship, again, whether it's the start, the middle, or the end, employees have rights. Employees oftentimes have far more rights than what they actually think they have. Our employment laws in Ontario in particular are actually quite favorable to employees. They're quite protective of employees. But the law will not protect you if you don't know what the law is, if you don't reach out and ask an employment lawyer what your options are, what your rights are, what you can do if your employer is mistreating you, or if you've been let go from your job, whether you have been offered a severance package or not. Again, that is what we are here to talk about today. We are here to talk about your employment rights, what options you have in the context of your employment. And this is a live stream. So if you have any questions, please feel free to reach out, post your question right now. Again, I'm an employment lawyer. I will answer your question. And I promise you, as much as, of course, I could help over the course of a live stream, I will be able to provide some guidance and likely a high degree of guidance. If perhaps you're too shy or too bashful to ask your question online, that's okay. Go ahead and give us a call at the office or send us an email at the office. Let's have a private conversation about your matter. If it's particularly complicated or if it's particularly sensitive, again, don't be shy. Reach out to us at the office. The initial contact with our intake team is absolutely free, and certainly we'd be able to help in any way we can. I want to start, as we usually do, with some contact information. So if you do want to get a hold of us off air, first off, go ahead and visit our website. Employmentlawyer.ca is where you can find all of our basic contact information. Of course, our contact information across our various offices for lawyers, and we do have offices across Canada in Vancouver, Calgary, Toronto, of course, and Ottawa as well. Go to our website. We've got a ton of resources on our website, blog posts, news articles, a ton of video clips, and you can actually start there for some preliminary research. We have articles on a ton of different topics and lots of different resources. If you want to get a hold of us by email, and actually, if you're dealing with an employment issue, I would suggest you send us a brief email. Don't send us email that's pages and pages long telling us your life story, but send us a brief email, maybe a paragraph or two outlining your general situation. If you've been let go from your job or whatever difficulty you're having at work, help@employmentlawyer.ca is the email address. Once again, that's help@employmentlawyer.ca. Go ahead and send us an email there. I promise someone will get back to you. And again, give us a brief description of the situation that you're dealing with. You can also, of course, give us a call at the office if you'd like. I don't know the number by heart, quite frankly, but we'll have it on the screen. There it is. Give us a call at the office. Again, we have an entire intake department standing by to speak with you. If you can't get a hold of someone at the first try, listen, go ahead and leave us a detailed message. It is all completely confidential. You're calling a lawyer's office. You're calling a law firm, so it is all confidential. Leave us a message. Again, I promise someone will get back to you. That's our contact information. Guys, please go ahead and reach out at the office, either by email or over the phone, or visit our website. But for the time being, and for the next 25 minutes or so, once again, this is a live stream. Go ahead and ask your questions, post your questions online right now, and I promise I will get back to you. I already have a couple of questions lined up here from Taylor and one from Paul. Thank you so much for the questions, guys. I will get to them in a sec. I did first want to speak about a subject that, and this is what I will typically do on these live streams and on our radio shows as well, for that matter, wanted to talk about a matter that has come across my desk most recently. I have spoken about this in the past more than one occasion, but I am seeing it more and more and more, and it is becoming increasingly a problem when it comes to termination of employment. And this is particularly the case for shorter term employees, or alternatively for employees that have recently signed employment agreements. It's important to keep in mind that when an employer is offering an employment agreement to an employee, the purpose of that employment agreement, the purpose of any employment contract, is to limit the liability and limit the risk for the employer. An employment contract very rarely provides additional benefits or additional guarantees to an employee. That employment contract that your employer is asking you to sign, whether it's at the start of your employment relationship or during your employment relationship, again, it is likely only being offered to you for the benefit of the employer. And I am seeing this increasingly. We're seeing an uptick in terminations. I think it's a sign of kind of the economic times that we're speaking with lots of people who have recently been let go from their jobs, and they're relatively short service employees. They've been within an employer for only about a year, perhaps 2 years, there or thereabouts, and they're being offered severance packages. However, their employment contracts contain language that potentially limit their severance entitlements. Now, a lot of contracts, a lot of the termination provisions in employment contracts will be unenforceable. And so if you have an employment contract that has some language in it that speaks to what you might be owed in the event of a termination, usually there's a paragraph or two in the employment contract that's titled termination, or sometimes it's termination without cause, that says, in the event that we let you go, this is what we're going to pay you. Now, those provisions, those termination clauses, as we call them, need to be very, very carefully drafted, very, very carefully worded. The use of even one wrong word or one wrong phrase in a termination provision like that can render the entire provision unenforceable. And so I don't want employees out there to just assume that if they have termination language in an employment contract, it limits their severance entitlements. But what I will say is sometimes, again, especially for much more recent newer contracts that were signed in, let's say, 2021 or 2022, those contracts will be enforceable, and that limits the severance entitlements that an employee has when they're let go. And so the kind of message that I have here, and the lesson and the heads up ultimately that I have here for employees is, if you are a new employee, if you're being hired on to a company and you're being offered an employment contract, it is important to look at the details of that contract. The devil is in the details. Don't just look at your salary and your benefits and potentially your bonus and your vacation. Of course, those are the big ticket items. Don't get me wrong. But look at pages 3 and 4 and 5 of that employment contract, and you will find language in there that speaks to your termination entitlements. It is important to understand that language. You may even want to speak to an employment lawyer before you sign an employment contract. Oftentimes, those kinds of provisions are negotiable. You can actually negotiate the terms of your own severance package. And I know that's a little weird to think about at the start of an employment relationship, but it's important. It's important, particularly in difficult financial times where you might be starting a job and 6 months later, due to a restructuring or due to a financial struggles, your employer might be letting you go. So again, if you're a new employee and you're being offered an employment contract, make sure you understand the terms of the contract fully, every single term, including the termination language, and speak to an employment lawyer if you don't understand what it means or if you're looking to negotiate those terms. If you're an existing employee of a company and out of nowhere, really, or even if it's in the context of a promotion or a raise, you are being offered an employment contract to sign, it should be a massive, massive red flag. Again, the only reason your employer is offering you an employment contract mid-employment is because it is looking to limit your rights, limit their exposure and their liability. And oftentimes, if not always, that is going to be in the form of severance. If you are an existing employee and you're being offered an employment contract, the default rule should be don't sign it. Don't sign it. At least don't sign it until you've spoken with an employment lawyer. And once again, give us a call if that's a situation that you find yourself in. Again, this is a red flag situation. Even if it's in the context of a promotion, even if it's in the context of a raise. Again, the only time an employer will offer you an employment contract mid-employment is because it is looking to limit its liability to you. Okay, guys, that is the lesson of the day, so to speak. And again, something that I'm seeing very often now. We speak to lots of individuals every single day and every single week, and it's something that I'm seeing come across my desk very, very often. Once again, for those of you just tuning in, my name is Alex Lucifero. I'm an employment lawyer with Samfiru, Tumarkin, and also disability insurance lawyer. And to that point, if any of you out there are dealing with a medical leave of absence, or you're applying for short-term or long-term disability benefits, by all means, go ahead and post your questions. If you're wondering what your rights are in the situation, whether your employer is doing something properly or not, or legal or illegally, again, go ahead and ask your question. I see a few here lined up, so I'm going to be getting to them right now. Again, really anything employment related, anything under the sun when it comes to your workplace and your workplace rights, please go ahead and ask them right now, and I promise I will get to them. All right. And in that respect, getting to the questions, guys, first in line was Taylor on Facebook. Thank you for your question, Taylor. You ask, if your company has recently been sold, are you automatically hired by the new owner? Interesting question, Taylor. And I mean, the answer, like many things in the employment law world and many things in the legal world as well, is, well, it depends. It depends on whether the new owner or the new entity, the purchasing company, so to speak, is actually going to be hiring you on. So your employment transitioning to the new employer isn't necessarily guaranteed or automatic. There has to be an offer of continued employment there. It actually speaks very well to the point I was just making about employment contracts. Oftentimes, in the context of the purchase and sale of a business, we will see the purchasing company introduce new employment contracts. Again, that is a red flag. You need to review that contract very, very carefully and make sure that you know what you're signing up for, that you know what you're agreeing to. And again, look out for termination language, or look out, quite frankly, for any new terms of employment, if that's the case. If you are being hired on by the purchasing company, if you've been extended an offer of continued employment, then your employment does continue. And your previous years of service, this is very important, your previous years of service with the selling company continue on. You don't start as a day one employee with the purchasing company. Your seniority, your years of service carry on as though your employment has been uninterrupted. So in that respect, Taylor, I mean, it is kind of automatic in the sense that your employment continues from one company to the next, from the selling company to the purchasing company. But again, it's not necessarily automatic in the sense that, well, the purchasing company needs to actually want you to continue your employment. If they don't want to continue your employment, well, that's effectively a termination like any other. And the selling company would owe you severance in a case like that. So you would still, let's say the purchasing company doesn't want to keep you employed, right? Your employment has come to an end. It's not by choice, right? You haven't decided to resign. It's not a resignation, certainly. It's a termination like any other. You are going to be owed severance in a case like that. Your severance is going to be based on your age, position, and years of service. The older you are, the longer you've been with the same company, the more senior or the more specialized your position is with that company, the more severance you're going to be entitled to. And in that respect, if you want to know what your severance entitlements are, very quickly, confidentially, at absolutely zero cost, pocketemploymentlawyer.ca is the website you can visit, answer a couple of questions about your age, position, and years of service, and out will come an amount of severance that you are owed. And even if you're just curious, even if termination is not even on your mind, and you're just curious what severance you would be owed in the event of a termination based on your age, position, and years of service, go ahead and visit the website. Again, pocketemploymentlawyer.ca. Go ahead and visit, input a couple of criteria. You don't have to provide a phone number or email address or any confidential information. Use it at your leisure. Thanks for the question, Taylor. It's a very important one. And again, it's one where employment contracts become important. So in the context of a purchase and sale, if you're being offered continued employment and there's an offer letter or an employment contract or agreement that comes along with it, before you sign it, before you accept it, make sure you speak with an employment lawyer. Great. All right. Next up in the queue here is Paul. Paul, thank you for your question. Paul says, I work as a technician for a car dealership in Ontario. The other day, their computer systems went down. I am paid using this computer system. Since it was down, I was unable to work and therefore not paid. It was not my problem that the system was down. I left because I was not being paid. Does my employer owe me at least for the time that I remained there? A good question, Paul. And it's actually a very simple answer, and I think a common sense answer, which is that your employer owes you pay and time for the time that you actually worked. So despite the fact that maybe the system is down, if you stuck around, perhaps hoping that it would come back up again very quickly, and maybe did some other things in the meantime, cleaning up perhaps, or any other odds and ends, but you were to a certain extent working, right? I think you're certainly owed for that time. Now, if the system went down and you were effectively sent home at some point during the day, I think your employer is reasonable to say, well, you're not paid for that time, particularly if you're paid on an hourly rate basis. I would say if you're paid on a salary basis, then I think it would be a question simply of making up that time or accounting for the time that you didn't work in some form or fashion. But, again, if you went home, right, and were unable to work, I certainly appreciate it wasn't your fault. Wasn't the employer's fault either if a system went down and there were some computer issues. I mean, this does happen in the workplace. If you weren't working, they have no obligation to pay you. It's really as short and simple as that. If you stuck around and did to a certain extent work, even if it wasn't your usual tasks necessarily, and again, you did some odds and ends while you were waiting for the system to come back again, I think you should be paid for that time. Certainly. In these kinds of cases, Paul, and you mentioned, you work in Ontario, and this would be true of any other province for that matter as well. For items like this, when we're dealing with a wages issue, or for example, Paul, if you're dealing with an issue about vacation pay perhaps, or overtime pay, the Ministry of Labor is actually a useful tool here. And again, when we're dealing with either the Ontario Ministry of Labor or any other Ministry of Labor in any other province, again, when we're dealing with issues of whether or not you should have been paid for a certain amount of hours, or breaks, or vacation pay, items like that. Contact the Ministry of Labor, speak to an agent there. They would likely be able to point you in the right direction. And if they feel that there's a claim there to be had, you can actually file a claim with the Ministry of Labor and proceed that way. That actually is a very efficient way to proceed when we're dealing with those kinds of specific issues. Now, if we're dealing with issues of severance, or issues of termination of employment, I want to be clear in my advice here. The Ministry of Labor is the wrong place to go in those instances. The Ministry of Labor cannot tell you what your full severance entitlements are. They cannot assist you in obtaining your full severance entitlements. If you go to the Ministry of Labor with respect to termination and severance pay, in almost every single case, they will lead you astray. They will give you the wrong advice and wrong information. Do not go to the Ministry of Labor if you're dealing with the termination of employment. If you're dealing with unpaid wages, perhaps, during your employment, or vacation pay, or minor issues like overtime pay, go to the Ministry of Labor by all means. But do not go to the Ministry of Labor when it comes to severance or termination of employment. Paul, if you have any concerns, contact the Ministry of Labor. By all means, it just takes a conversation, right? It takes a few minutes' time. It might be worth it in a case like yours where there might be some uncertainty there. Maybe your employer disagrees that you did some work that day and they don't want to pay you at all. That would be inappropriate. But the Ministry of Labor can help in a situation like that. Hopefully that helps you, Paul. And listen, any other concerns, any other questions? If things get more serious from here, if your employment does come to an end, or if your employer is looking to change your terms of employment in a significant way, again, all of that should certainly be a red flag. Give us a call at the office, send us an email, any way you can, really reach out to us and contact us. And thanks again for your question. All right, Jacob is next in line. Jacob on YouTube asks, I was recently terminated. I asked for time over so that I can focus on my health. I suffer nerve and neck pain. I'm recovering from Parsons-Turner syndrome and have been diagnosed with a disability. Jacob follows up in a second post. My HR gave me the option of going on FMLA. However, my manager asked me to delay this as much as possible because our peak season is during the summer. Jacob, a few weeks later, I was terminated. Jacob, if you can just actually post very quickly, if you're still tuning in, I imagine you are. Let me know where you are. I'd be curious what province or what state you're in. I want to be clear that my advice is only going to be relevant to the province of Ontario, and I could speak to kind of the law in Canada more generally, but I only practice law in Ontario. And so if you're in Ontario, great, I can certainly help you there. And there are some serious red flags raised in your question. But if you're in the States, Jacob, or if you're in any other province for that matter, the legal analysis might be different. And so that is my disclaimer prior to answering your question. But let me answer the question generally, because I think there's some really important points to be had here. Number one, when you are dealing with an employee who has a medical condition and who potentially has to take a medical leave of absence or some sort of leave for medical reasons, an employer should be treating that employee with velvet gloves. Employees that have medical conditions have to be accommodated in the workplace. There are no ifs, ands, or buts when it comes to that situation. If an employee is being suggested by their doctor, by their treating physician, to take a medical leave of absence, it doesn't matter whether it's a busy season or whether it's peak season or whatever season it might be. That employee should be following their doctor's instructions and taking a medical leave of absence. Their job is protected by law. They cannot be punished in their job. They cannot be treated any differently in their job. Because they are required to take a medical leave of absence. Of course, it's not that employee's fault that they're having to take this medical leave. They're dealing with a disability. They're dealing with a medical condition. And again, the law is very, very protective of employees in that situation. So, Jacob, I don't care really whether your employer was saying that it was in peak season or wasn't a good time for you to be taking a medical leave. You had every right to take that medical leave at the time. And even if we're not talking about a medical leave, even if we're just talking about accommodation in the workplace, maybe you can only work a certain amount of hours per day. Maybe you have to take frequent breaks at your work because of your medical condition, or really any other accommodation that you could think of. Perhaps you can only work from home, or perhaps you can only do certain type of work. Maybe if you're a general laborer, you can't lift heavy objects, you can't do certain movements. All of those kinds of tasks have to be accommodated in the workplace by your employer. If they don't, it is a violation, at least in Ontario, Jacob, it's a violation of the Human Rights Code. It is discrimination on the basis of disability. It is illegal, full stop, period. To make matters worse, Jacob, if you've been let go, so I just saw your post, Jacob, you're in New York City. Listen, I'd encourage you to speak with an employment lawyer in the city or in the state for that matter. I am sure they have laws about discrimination as well on the basis of disability. If you have been terminated as a result of your medical condition, that is going to be discrimination. So speak with an employment lawyer in your area. Unfortunately, we don't practice in the United States. We only practice in Canada, in British Columbia, Alberta, and Ontario. Perhaps our next endeavor should be opening up an office in the U.S. But again, Jacob, speak to an employment lawyer in your state, and they could certainly be of assistance. I can also add, again, when it comes to Ontario and Canada more generally, if an employer terminated an employee because they had to take a medical leave of absence or because they required accommodation in the workplace, again, that is discrimination. It's effectively the most severe form of discrimination that you can think of, actually ending an employee's employment because they're dealing with a medical condition. Of course, that employee is going to be owed severance. Not only that, they are going to be owed additional damages as well, again, for discrimination, for reprisal in their employment. That employer is in for a rude awakening. You cannot terminate an employee because they have to take a medical leave of absence or because they need accommodation in the workplace. Again, it is illegal in several different ways. Thanks for your question, Jacob. I wish you the best of luck. Again, speak with an employment lawyer in your area. If you're in the New York City area, I'm sure you can find an employment lawyer quite easily. All right, just a couple of minutes left here, guys, and we're going to go ahead and answer, I guess, our last question of the day, at least for now. Might be your opportunity if you're just watching this and you have a question related to employment law, related to your workplace rights. We've got a couple of minutes left. Squeeze in that question, and I'll try and get to it. I've been known to go over time if I see questions coming through. So again, feel free to ask, guys. But Natalia asked, Natalia next in line, can employer vaccination policies still be justified? I'm in healthcare sector. Can employers terminate based on vaccination status? They do not mandate the booster, only primary series. Natalia, great question. We've been dealing with this issue over the course of the year. The answer to your question is context dependent. And so, for example, if you're in the healthcare sector, I think the bar is a little higher when it comes to vaccination of employees. I think those industries are treated a little bit more delicately and err on the side of caution when it comes to vaccination policies and whatnot. That said, I do have to say, personally, my opinion is terminating an employee on the basis of their vaccination status. Certainly in a situation like that, I believe an employee should be owed severance. And so it may be justified to let an employee go based on a vaccination policy, based on their vaccination status, but that employee may very well be entitled to severance in a case like that. It is really a question of whether refusing to be vaccinated rises to the level of having cause for termination. Cause for termination effectively means that your behavior is so terrible, so egregious, that the employer is really left with no choice but to terminate your employment without any notice and without any severance whatsoever. That is what a termination for cause is. Termination for cause, I can tell you, are reserved for the worst of the worst kind of behavior in the employment relationship. You could think of examples of this kind of stuff: theft in the workplace, fraud in the workplace, really egregious behavior, violence, severe bullying and harassment, all of those kinds of real things that very obviously and fundamentally go against the very nature and the very trust implicit in an employment relationship. That is what a termination for cause is. Now, Natalia, my opinion is that failing to be vaccinated, does not rise to the level of having cause for termination. Particularly, and I just saw your note here, Natalia, if you're working from home. My word, if you're working from home, if you're a remote working employee, and your employer is letting you go because of a vaccination policy, quite frankly, I think that makes zero sense whatsoever. It just doesn't make practical sense, right? Why would you have to have an employee vaccinated if they're able and are currently working from home? I mean, it just doesn't make sense. But in addition to that, of course, that employee is going to be owed severance. They're going to be owed severance based on their age, position, and years of service. I would say particularly, Natalia, for remote working employees, from employees that work from home, these vaccination policies just make no sense whatsoever. If you haven't already, Natalia, go ahead and reach out to us. Again, especially if you're in Ontario or British Columbia or Alberta, go ahead and reach out to us. Let's have a call off air. Again, these vaccination policy issues are very delicate, very context specific. And so let's get into the details of your situation. Certainly we'll be able to point you in the right direction. And, we're quite bullish when it comes to standing up for employee rights, standing up for employees' entitlements in the workplace. And so, if anybody can help you, really, it is us. We will leave it at that. And we're right on time, guys. That's perfect. Thank you all so much for tuning in. I hope you enjoyed today's session. Once again, my name is Alex Lucifero, employment lawyer and managing partner at Samfiru Tumarkin LLP. I'm wishing you all a very good end to the week. And for our Canadian viewers, a happy long weekend and Thanksgiving weekend. Until next time, guys, we will catch you here on our next live Q&A. Have yourselves a great day. So long.